your phone on?
Good morning and welcome to AM News Network Presents the Morning Report with Rachel Baird and Ed Peruta. I'm Rachel. Seated next to me is Ed, as he is every Monday through Thursday.
Almost.
7 to 7:30 a.m. Join us as well on Saturdays for our Summary Judgment flagship show from 4 to 6. I think I just kicked a dog.
No, you kicked.
Okay.
You kicked
Good.
this thing here.
Good. So, Ed, how are you?
I'm fine.
You know, we have been counseled, and I completely agree. Master Control's back, and he has counseled us not to really go into the eclipse because I think enough has been said about it. Everybody's been talking about it, but I do want to offer one little snippet from a different perspective that not everybody may be aware of. My understanding is that now everybody knows that the Department of Correction in various states, including Connecticut, allow the lower risk level inmates to go out in the community and work. You know, they clean schools, they do road work, not while school's in session, just during the summer. I just want to clarify that.
It's called the chain gang.
Well, they don't really have those anymore. But anyways, they pay, at least here in Connecticut, they get paid $1.75 a day. And my understanding yesterday is that throughout the Department of Correction in Connecticut, all of these day workers were brought back to the facility by 12:30, and there was no outdoor rec during the afternoon because there was a concern that the inmates would look into the sun. Now,
The state didn't have enough money to buy glasses for them.
Exactly. So I just gathered that information from the inside, and everybody may not have been aware of that. So I don't know. I just found that kind of touching that DOC cared enough to make sure that none of the inmates were outside and exposed to the potential of looking upward at the sun. So what else is going on, Ed? We had a hearing yesterday in Bristol that is continuing onward. That's what we did yesterday.
That is a very interesting case for reasons other than why we're there.
Yeah, it's a firearms risk warrant hearing, and we were in our third day yesterday, which sounds like a lot, but actually it's not, because they're scheduled for 2 p.m. in the afternoon.
And they don't start till 3:30.
Yeah, because the court has to finish its regular
docket. So you get an
docket.
hour and a half, an hour and a half, an hour and a half.
Yeah,
but
that's okay.
The part that is coming out that I find enlightening is when you're questioning these public employees, whether they're a police officer, a dispatcher, an EMT, whoever, they're all using their personal cell phone devices to conduct department business.
Yeah, that's exactly right. I said to the witness yesterday, I said, you sent text messages that really are what this case is all about to an officer in the Plymouth Police Department. How did you send them? To a cell phone. Personal cell phone? Yes. How did you know his number? Well, I had his number because they're
all friends.
Because they're all friends. And so basically the most crucial bit of evidence in the case is being relayed to the police department on the personal cell phone of an officer. Okay? And when I requested the complete police file, copies of those texts were not in the investigation record. So the only place where the Plymouth Police Department has copies of the evidence in the case is on an officer's personal cell phone, and he may or may not still have it. I subpoenaed him, but he's on vacation, a year-long planned vacation, of course, and I knew the case would probably be continued to another date anyway because we wouldn't finish. So we've yet to ask him, do you still have these messages on your personal cell phone that were never apparently printed out and kept in paper form in the case jacket investigation file at the police department? And in this case, okay, whatever, you know, it's not a criminal case, it's a civil case. In how many criminal cases is there evidence and communications going back and forth and among and between officers and witnesses on personal devices that is never ever captured and made available in the investigation file for defense attorneys, for prosecutors, for judges, for witnesses, for anybody. That's a problem.
Well, and you know that I have been talking about this for years. Because in the Rocky Hill Police Department, Sprint, one of the cell phone companies, purchased a company that was called Nextel. And Nextel phones had like a walkie-talkie feature. And I knew 10 years ago, 12, 13, 14 years ago, that Rocky Hill police officers, rather than picking up the microphone in the cruiser to talk to a supervisor, were talking on Nextel. And if you talk on Nextel, you avoid public scrutiny of what you said, and it allows you to control the narrative of what happened. And there's no way people were looking at personal cell phone devices and they don't record what has been said. So they can say, well, I didn't say that. Or, oh, I told him this. And it's just, and I know I was sitting next to you at the table. And I could anticipate your questions, your line of questions, because I think that in your practice, probably more so than other attorneys that I've heard, are very aware of this personal communication device concept, and you start zeroing in on it.
A lot of times I'll get asked, or there will be comments made, you know, what are you making such a big deal out of this for? You know, what's really at stake in this hearing? And if I have a client that is willing and wants to put the case to the test through a hearing or a trial, I always use that opportunity, because it is in the best interest of my client to uncover everything. I always use that opportunity to get to the bottom of what really happened in the investigation and what went on. Because 99.5% of cases, I just grabbed that out of the air, but I think it's pretty accurate, are plea bargained or dropped. Never, no witness ever comes to testify. The police are never asked to bring documents or anything else. So everything's just taken at face value. And I find that in every case, when you explore it, there are things that come out that were never apparent on the surface. Now, they may or may not help eventually your client. You know, not everything helps. But
let me see if I
can.
But
imagine if every case were explored that way. But it can't
be.
Let
me see if I can sum up what I've observed and what I believe now. One, your best attribute is finding the devil in the details.
Well, you do that too. I mean,
that's
why we work together.
I do, but totally different from you. But you find the devil in the details. Now, that's number one. Number two, you leave very few stones unturned.
I mean, did you hear that complex? I can't even remember what I said, but hypothetically, there's a report, and the investigating officer wrote the report. And in the report, he says that he spoke to a witness, not a witness to anything direct, but he spoke to a witness who said that
they talked to the state police in Massachusetts.
That he talked to the state police, and the state police talked to somebody else in Massachusetts, and that person in Massachusetts had made a negative comment. And I'm thinking, we have a written report here with something that somebody else said that somebody else said, and the Massachusetts police report says nothing about what the witness said that the Massachusetts report, the officer said that somebody else said. How on earth?
Whoa, I got to add something.
How on earth do you attack that?
We've got, sitting in the courtroom, the person who's alleged to have said what eventually the telephone says, the game telephone said something going like this. I never said that.
Now, before the officer put that in the report, maybe he should have skipped over what the witness said, that the state trooper said, that the other witness said, and just called that other witness directly and say, "Did you say this?" That might have been something to explore.
Well, and I believe that
but how do you attack something like that? Because there's so many levels. So you can't really hold anybody accountable for that statement, because the witness is going to say, well, that's what the state trooper said. The state trooper's going to say, well, I never said that, or that's what, there's no, the statement is so diffused.
How do you get the Massachusetts state trooper into Connecticut?
Well, yeah, that's
okay, but
he wrote a report.
There's other aspects, you know what I mean? This is probably going to end up being a firearm related risk warrant type show, but the state of Connecticut was so zealous in attacking firearms and firearm owners and individuals who had firearms around them that they threw constitutional safeguards to the wind.
You brought up a really interesting observation yesterday. In Connecticut, to get a risk warrant, you need 2 police officer affiants, right?
Right.
I don't know. Maybe we should look that up, because I feel like in the Berlin case there was just
Excuse
one.
me. Nope. Let me explain something to you. And I'm going to start like this.
Let's look that up.
The Hartford Courant, the New Haven Register, the New York Times, in order to write a story or even at a news desk, the news director insists that you confirm the fact through 2 independent sources before it goes out.
That can't be true anymore.
Yeah, well,
there's no way that's
fake
true
news
anymore.
But what I'm saying is 29-38C requires 2 sworn police officers to attest to the facts.
Why? Why not just 1?
They require 2. It takes 2. Now, so you had one.
No, but I'm asking you for your theory behind why the legislature put into the statute that 2 are required.
For the
why
same
not 1?
reason. For the same reason that a news desk required 2 valid, confirmable sources before they published. In other words, 1 may not be good enough. You got to have yin and yang. You got to have somebody playing the devil's advocate, and if they both agree, then it's solid. It's pretty solid. But what happened was this. You had already questioned the first person who swore to the statement to get the risk warrant, and you had the second person in the courthouse under subpoena to talk on the stand.
To make sure.
And, union rules, marshals go, the courthouse gets locked down tight at 5 o'clock. You weren't going to get to talk to that other, what they call an affiant.
I got to tell you though, I want to give positive feedback on the Bristol court personnel, because we were there past 5, and I've been in other courthouses.
Let me tell you.
I've been in other courthouses where when it gets to 5, you would think there's going to be an explosion if you're not out by 5 o'clock.
Right.
But they weren't like that. We were allowed to.
But you know something? We're not talking about that right now.
Okay.
They're very pleasant in the Bristol courthouse to us.
Yes.
Very professional, and I agree with that. But what happened was, it was getting ready to leave. And as your investigator, I asked you if I could ask the affiant, the second number 2 affiant, who had not yet gone on the stand. As your legal investigator, can I ask him a question? You said, "Oh, go ahead."
Oh God, what?
Okay, go ahead. So I said, officer, I'd like to ask you a question. before you affixed your signature attesting to the facts, did you or anybody call the hospital to find out how long this individual was in the emergency room for evaluation and what happened? And I was shocked because he went like this. He said, well, you want me to tell you the truth? He said, I came into work. I was presented with the warrant application. It had been signed by a police officer and had been approved by a supervisor. I was asked to sign it. I signed it. I said, so you signed it, but didn't know anything about what you were signing. I mean, you read it, but, you know.
So here's the statute. Upon complaint on oath by any state's attorney or assistant state's attorney or by any two police officers.
Right.
To any judge of the Superior Court that they have probable cause to believe a person poses a risk of imminent personal injury to himself or herself or to other individuals.
That's enough. Affiant number 2. Read that again. What do they have to have?
Probable cause.
Probable cause to believe. Now, there was another word in there. Could you just read it again?
A person poses a risk of imminent personal injury?
No, where it says two police officers.
They have probable cause? That's all it says.
Okay.
Yeah.
All right.
Upon complaint on oath? Is that what you're talking about?
Okay.
You want me just to read the whole thing? Okay. Upon complaint on oath by any state's attorney or assistant state's attorney or by any two police officers to any judge of the Superior Court that such state's attorney or police officers have probable cause to believe that a person poses a risk of imminent personal injury.
Okay, gotcha. Okay. Have reason to believe that.
No. Have probable cause
Probable cause to believe that.
Big difference.
How did the second guy that just walked in have any probable cause at all?
I have the answer to that.
They relied on a brother officer.
Yep, I've explored this issue before.
And that is the fly in the ointment.
So if all you need to do is rely on a fellow officer, why have two officers have to sign?
But here's my problem. I am an owner of firearms. I carry a firearm frequently. If any two officers walked into this, or anybody walked into this building and simply went like this, you know, Ed, we watched the show this morning and we think you're a little bit out there. We have an ambulance outside and we're going to sign a piece of paper. You have to go to the emergency room at Charlotte Hungerford Hospital and be evaluated to see if you're a danger to yourself or others. You don't have a choice. When they fill out that piece of paper, they'll use force to get you into the ambulance. They'll handcuff you.
Okay, where are you going with this?
Okay, now, I go to Charlotte Hungerford. I get there at 8 o'clock. They see me at 8:15 and they release me at 8:30. Now let's go to the probable cause to believe. The doctor sits me down, evaluates me, has a discussion with me. He may even watch a rerun of the show on YouTube. And he goes like this, you know something, Mr. Peruta, there's nothing wrong with you. You're free to leave. And I walk out the door. 2 days later, 2 police officers sign an affidavit that I was taken to the hospital because of what was going on TV, and a judge signs the warrant. They come and they seize my firearms. I have to have a firearms hearing. I get my pistol permit revoked. I have to hire a lawyer and wait 2 years to get a hearing. Now, when a person is released from a hospital who's been brought in on an emergency evaluation form and the doctor lets him go, your probable cause to believe that he's a danger to himself or others is gone.
Okay, stop. This is what the statute says about that, 29-38C, the risk warrant statute. It says, such state's attorney or police officers shall not make such complaint unless such state's attorney or police officers have conducted an independent investigation and have determined that such probable cause exists and that there is no reasonable alternative available to prevent such person from causing imminent personal injury to himself or herself or to others with such firearms. So if a person goes to the hospital and is released, we can rely on those medical providers to have made a decision that does not allow somebody to be released who presents an imminent danger to himself or others, right? And so these officers are supposed to conduct an independent investigation and state in the warrant, or they have to determine that no reasonable alternatives are available. Well, when somebody's taken to the hospital and a medical provider says, get out of here, I don't know why you're here in the first place, to me, that was a reasonable alternative. It's been explored. The reason for the risk warrant goes away. And I've made that argument so many times, and it never, ever works.
Okay, now, I'm going to say this to you. I've said it before. I'll say it again, and I'll say it till I'm red in the face. All of our challenges to the Connecticut risk warrants and how they operate have been in state courts. I believe that a federal challenge to the shit that's going on would, in fact, have a different outcome. Now, what I'm trying to say is this, and you have to go back to this part of it. And I know people that this has happened to other than clients. If you're so distraught and so stressed that I'm concerned for your safety or the safety of others, and I call the police and you go into the hospital and the doctor sees what I saw, he has the right to hold you.
Well, he has to.
No, he has the right to hold you for 72 hours.
Yes.
After 72 hours, he must let you go unless they bring in a probate judge who agrees with either the person being held or the doctors who want him held longer, and a probate judge can order you be held beyond 72 hours.
But it's just so sad that this whole thing is a joke, because they come and they want your gun. You've already gone to the hospital and gotten out and been released, and they want your gun. And the reason they want your gun, the authority under which they take it, is that you're a danger. So I guess you could say, you know, they care about you, or they care about people you might hurt. Is that the impetus for this whole risk warrant thing? Stop. But yet you have knives in your house. You have a car that you have a car that everybody has seen in Barcelona. You know, name the places where Charlottesville, name the places where cars have been used as weapons lately.
Or as vehicles of suicide.
So you have all these means available that person could still use to hurt themselves or others, but you just take the gun and you leave them on their own devices. You take the gun from somebody who you're taking the gun from because supposedly he's an imminent danger to himself or others, but you leave him there with all the other instruments that he or she could possibly use to hurt himself or others. That is the true joke and disgusting nature of this law. But the fact that they use the law to act like they care about people when in the actual implementation of it, no care or regard is shown at all for people, and the only thing that happens is you separate people from their guns.
Okay,
that's it. Okay. Who have committed no crime.
Can I get in a little bit? Okay. I maintain. Now, when I asked this officer if he had checked, oh, well, they won't tell us because of HIPAA. They won't tell us because of HIPAA. And I said, well, if he was taken to an emergency room in Massachusetts on Saturday night, and he's walking around your town in Connecticut on Sunday afternoon when you go to the house to take the weapon, he's not in there for 72 hours. He's not in there on a probate court order. He has not been committed.
Did you check to see if he escaped from the hospital? Like one flew over the cuckoo's nest?
Right. Now, so what I'm saying
I
is,
don't know if he escaped
what I'm saying is, because they allow officers to sign affidavits and apply for warrants after the seizure, okay? Because 9 times out of 10, when they're putting you in the ambulance to take you to the hospital, they're taking the firearms without a warrant. And then because you walked into an emergency room, they apply for a risk warrant. That is not the way it works. It is prima facie evidence that you are not, I repeat, not a danger to yourself or others when they allow you to walk out of that emergency room.
That's right. And if you're going to then take the firearms from somebody who's been released from the hospital, you need to send them right back. Because at the time you're taking the firearm, they're a danger to themselves. So they need to go. You need to say, doctor, you have made a mistake. You have committed medical malpractice, and this person needs to go back.
Can you imagine a person who is clearly a danger to himself or others being told just walk out the door, and then he kills 5 people in the parking lot of the hospital, and they say, didn't you just have him in here? So doctors, who are also very concerned with owners of firearms, would usually not let somebody go if they thought they were a danger to themselves or others. It is police officers, if nothing else, need to ask the person when they see him in the community 3 days later, oh, do you happen to have your discharge papers? You know, because if you have your discharge papers, what's the sense in going for the warrant? Obviously, they think you're not a danger to yourself or others.
Or did you escape from the hospital?
Or did you escape from the hospital?
Okay, we're going to wind it up. We'll see you tomorrow at 7 o'clock. Thanks, Ed.
We will. Okay, bye.
Have a great Tuesday.